Welcome back, everybody. Um, this panel has been given the prime time position of after lunch, where we guarantee to keep everyone fully awake and focused with a fiery discussion. So very, very happy to kick off this afternoon's session. On behalf of my panellists, I wish to acknowledge the people of the Kulin Nations on whose land we are gathered today. I pay my respects to their elders past and present. I also recognise that Indigenous Australians have long been amongst the most powerful advocate for human rights accountability in this country, particularly on questions of state power over life and death, including deaths in custody. Their advocacy has driven Australia's engagement with international human rights law, making their experience deeply relevant to the work that we're here today to discuss. My name is Sarah Koval. I'm the Director of Elios Justice at Monash Law. Elios Justice was established through a partnership between Monash Law and the Capital Punishment Justice Project, which was formerly known as Reprieve Australia. I'm truly delighted to have one of the founders of Reprieve Australia here with us today, Richard Burke, who, along with Christine Lerman, have come to Australia after a quarter of a century doing incredible capital defence work in America, and it's great to have them join us today. Through research, advocacy and teaching, Elios Justice has become a vital hub for challenging the use and scope of the death penalty in Asia. It is with this lens that I came to the topic of this panel, the experience of Australian judges on international courts. We have seen in a number of jurisdictions that the only way to limit the scope and use of the death penalty is through the courts, particularly when there's no political appetite to do so. But this issue is wider than the death penalty. Those advocating for more human rights-centred jurisprudence create spaces for peer-to-peer judicial exchanges where comparative experience can be shared with the hope of influencing approaches to jurisprudence. How does this theory hold when, rather than peer-to-peer exchange, international judges are appointed to the bench? Singapore's International Commercial Court currently has 7 judges from Australia. The Court of Final Appeal in Hong Kong has 3 Australian judges sitting on their bench, including 1 Australian judge who sits on both benches. When Australian judges step onto international benches, they bring the values and traditions of Australia's legal system and human rights framework. But international judicial service is not without its tensions. What obligations does an Australian judge carry beyond their own jurisdiction? What frameworks govern their conduct when the institutional cultures, political pressures or procedural norms that they encounter are fundamentally different? Does the argument from some foreign judges that it is important to have a seat at the table withstand scrutiny? This panel interrogates these considerations, ethical responsibilities and limits on Australian judges who accept these appointments on international judicial bodies. We're going to start with our first speaker, Associate Professor Rebecca Anion-Welsh. Rebecca Anion-Welsh is the Associate Professor of Public Law at the University of Queensland, where her teaching and research focuses on courts, security and democracy. Her full bio is in the program, but I do want to highlight that Rebecca's research has been cited by the High Court of Australia, recognised in awards from the Australian Academy of Social Sciences and UQ, and shortlisted for an Australian Legal Research Award and a Queensland Literary Award. We'll start with Rebecca.
Okay, thank you, Sarah, and thank you for the invitation to be here today and talk a bit about the frameworks around these judges, Australian judges on international courts. I'm going to speak very generally for the next 10 minutes because I know that the detail that these guys are going to get into is pretty riveting. But first, I'll add my own acknowledgement of the traditional owners on which we're meeting today, the people of the Kulin Nation, and pay my respects to elders past and present, as well as First Nations people here today, and acknowledge as well that this concept of foreign judges, of judges who come from outside one's community, speak different languages, and maybe lack connections to country, is not an unfamiliar one for our First Nations peoples. It may be, however, a little jarring to a lot of other people in this room or in Australia generally. We think of judges as being local, or at least from the same kind of national kind of identity. But foreign judges has a very long history, and I'm not here to tell you all about it. But suffice to say, kind of think of it hand in hand, at least in the common law system, with the fact that the Privy Council, sitting of course in England, was the highest court of appeal for all Commonwealth nations for so long, for Australia till 1986, for Hong Kong till 1997, and Singapore 1994. So this idea, particularly in the common law world, that nationality doesn't limit your ability to resolve cases, permeates the whole system. There are various rationales, though, as to why a court might decide, or a country might decide, to import judges from somewhere else. They may have a need, it may be a gap-filling exercise. It could be that you need to rebuild post-conflict, a kind of institution-building thing. You may have a need in a particular area, maybe a lot of cases, and you just need to import some extra hands on deck, or to draw in particular expertise. You may need someone who is distant from internal politics, again, something you'd find in a post-conflict situation, for example. And then there's the justification that it can enhance the reputation of the court. And we see lots of references to this. It's not kind of beneath the radar. Justice Joseph Fock of the Hong Kong Court of Final Appeal, in a speech in 2017, described foreign judges on the Hong Kong court as a demonstration of confidence in the independence of the Hong Kong judiciary, as an external affirmation of real value about the independence of that court, and talked about these judges as having a canary in the coal mine kind of role, which is worth bearing in mind for what we'll hear soon. There are varied motivations as well from the judges themselves, and that's not something I could pretend to speak to, but there's two halves of this dynamic. Now, if a judge is offered an appointment at a foreign court and they decide for whatever reasons to accept it, then what? Well, one of the first things that they're going to do is take an oath of office. And I've got a couple of examples. Oh, I never know how to use these things. No? It's on. It's on. I can't read that. Anyway, there's a couple of examples of oaths of office. You've got the oath from Singapore and the oath from Hong Kong. Now, the one from Singapore is very much along the same lines as what you'll see in Australia, in case you're wondering about that. What these oaths speak to, I kind of split into a couple of themes. The first is, what are these judges going to do? They're going to judge. They're going to apply the law to resolve disputes between parties about law and stuff. They're going to do some judging. But just applying the law as it's written isn't the whole gamut of the judicial role. There's something more there. And the oath even reflects this. You don't need to go into theory or crazy ideas to get there. Oh, not being able to see it may become an issue. Oh, thank you. How good is he? Thanks. Great. So let's take the Hong Kong one. It's not just applying the law, but to do so conscientiously, dutifully, in full accordance with the law, but honestly and with integrity, safeguard the law, administer justice without fear or favour, self-interest or deceit. The kinds of ideas that we're getting at here, thanks Kevin, are those great constitutional public law words: independence, impartiality and integrity. So they're there to decide cases in accordance with these fundamental values, independence, impartiality and integrity. Now they're vague words, but there's a lot written about them. And one of the really useful documents around that is the Bangalore Principles on Judicial Conduct, which would certainly shape how an Australian judge in a foreign court undertakes their role. It speaks of a whole range of things, impartiality being a lack of bias, maintaining competence, integrity meaning that justice must be seen to be done as well as actually done, propriety, But what it also comes back to is the fact that these values are not there for their own sake. We don't separate judges just because it's fun. The Bangalore principles describe it as, yes, I do have, a competent, independent and impartial judiciary is essential if the courts are to fulfil their role in upholding constitutionalism and the rule of law. So when the judges are there, they're also there to uphold two more vague words, constitutionalism and the rule of law. So what's the rule of law? Because we're speaking common law, I'm going to go to that darling of the common law, Dicey, and also because he gives us the most minimalist, thin possible conception of the rule of law, and there's still a lot in it. So the rule of law requires upholding the law, great, but it's not just that. That would be rule by law. The other things that Dicey points to are equality, that the powerful need to be held to account under law. And then this next thing is that a person is only punishable by law administered by the ordinary courts of the land. And here Dicey is speaking to the importance of fair hearing, of independent and impartial courts, and a prevention of executive punishment, of arbitrary punishment, that there needs to be law fairly administered in order to have the rule of law. Now, the third aspect of Dicey's rule of law is, I think, easy to kind of skip over, as I do with a lot of my first-year public law students, because it's a mouthful, and that's that the Constitution is the consequence, not the source of rights. But I think this is particularly pertinent in this context, because what Dicey was talking about here is that justice, fairness, liberty exist despite the law. You don't have those, I'm preaching to the choir in this audience, but you don't have those rights or those entitlements because they're given to you by law. You just have them. And Dicey had that faith in the common law system particularly to recognise justice, fairness, liberty, rights, and achieve those things in a way that he didn't trust bills of rights or written legislation to do. And then you pair that with the rest and you have the common law system administered by fair and impartial courts able to achieve those things. Now, more modern versions of the rule of law, such as the UN, by Lord Bingham, by the Bangalore principles themselves, would add respect for fundamental human rights, such as is codified in international instruments, to that conception. That's a lot of theory. I'm a constitutional lawyer after all. I could talk about Dicey for longer than is appropriate. But what does this mean practically for Australian judges overseas? They're there to apply the law and do so competently, but with independence, impartiality and integrity. And those things should be actual and perceived, personal and institutional. And they need to do so in a way that furthers the rule of law, and that at least, at a minimum, means equality, the subjection of powerful to law, non-arbitrariness, and seeking fundamental justice that grounds the entire common law system. And perhaps it's also informed by international law and fundamental human rights.
Thank you, Rebecca. Kevin Yam is currently a PhD candidate and part-time lecturer at Melbourne Law School. He spent nearly 2 decades in Hong Kong as a solicitor, with over 8 years as a partner at an international law firm specialising in financial, regulatory and white-collar crime defence, as well as large-scale commercial litigation. Kevin has also been and continues to be a Hong Kong democracy and rule of law activist, which resulted in the Hong Kong government placing a bounty on his head in 2023. He was subsequently disbarred as a Hong Kong solicitor, which led to many statements in support of him, including from the Law Council of Australia. I will hand over to Kevin now to speak about the Hong Kong judiciary.
Let me set my stopwatch. I would also like to begin by acknowledging the lands on which we're gathering. They're the lands of the Wurundjeri people of the Kulin Nation, and I pay my respects to elders past and present and to all First Nations people gathered here today. Now, I'll start straight away. I'm meant to press firmly. Oh, here we go. So, you're about to see a long-winded and eyesore set of slides. And let me explain. You can blame that on all the white splainers in recent years who have tried to tell me that my views on Australian judges on the Court of Final Appeal in Hong Kong is merely, you being an impulsive activist and you don't understand the nuances. So I'm not going to go through everything. I've only got 15 minutes, or now 14. And I just wanted you to see how many words there are, right? And so, actually, I've got even more words than that. I've got nearly 7,000 and counting words worth of this. If you want to see a fuller position paper on all of this, you can email me, and I'd be happy to circulate that. So, okay. So, a little bit of overall background. Why did Hong Kong have foreign judges on the Court of Final Appeal? It's the final appellate court. It was because when Hong Kong was being handed over back to China, there was a lot of fears that, the Privy Council is going to be gone. Can we still trust Hong Kong? And so they came up with this compromise saying, let's have some foreign judges on the final appellate court. That gets limited to just one foreign judge on any panel of 5 by statute in Hong Kong. So that takes me next. Okay. Now, Australian judges, they've been around in Hong Kong since 1997. Sir Anthony Mason, in particular, probably wrote a lot of the leading judgments on Hong Kong's early constitutional jurisprudence. And may I say right at the outset that just because I hold a different view about whether they should still be hanging around, I have a lot of respect and admiration for their good intent in wanting to serve the people of Hong Kong. Next one. Okay, so the turning point came in 2020. So on 30th of June 2020, China imposed the national security law on Hong Kong. And ever since then, there's just been a never-ending crackdown on civil liberties and on dissent, lots of people being locked up, others silenced, others with bounties over our heads. And for those of you who are students, I know that 160,000 or 180,000 Australian dollar bounty is tempting, but don't kidnap me to Turak. Turak is where the Chinese consulate is, by the way. So, yes, student loans are expensive. So, as at the time when the national security law came into effect, there were 15 foreign judges and there were 4 Australians amongst the 15. I'm not going to go into any great detail about the movements in and out of the CFA since then. Basically, 12 judges have left, and quite a number of them have actually expressed concerns about the direction that Hong Kong's traveling in as part of their resignation. And then others who say, I want to spend more time with my family, but then they stay on the Singapore court, right? So then nowadays, since 2020, 12 left, but 3 joined. And of those 3, 2 of them are Australians, Justice Keane and Justice Alsop. And one of them is actually a New Zealander, Sir William Young, who, interestingly, he joined and left the Dubai court because there were concerns about human rights in the UAE, but then he went on to join the Hong Kong Court of Final Appeal. Interesting. So then the next question is, why should we care in Australia about what Australian judges do in Hong Kong? Well, I think it's very simple. Look, there is no doubt that we've got some of the best judges in the world here, no doubt. But the thing is, as good as they are, if it wasn't because they're from Australia, no one would have appointed them, and I mean that, I say that without meaning any disrespect to them. And in fact, some pro-Beijing figures in Hong Kong pretty much acknowledged that when they said, oh, now that we couldn't get judges from the UK or Australia, we better start looking elsewhere as a bit of a backup. That already tells you that they're appointing these judges not just for their individual legal acumen, but also because they're Australians. So from an Australian legal fraternity perspective, hey, it's your reputation on the line when these judges stay on the Hong Kong Court of Final Appeal. So next slide. Okay. Now, my own view is no. I think it's pretty clear by now. I'll come to why. But in doing that, I emphasize again, I mean no disrespect to any of those judges. In fact, I really hate it when some of my fellow Hong Kong activists take cheap shots and say, oh, they just like the good money that they get paid in Hong Kong. Hey, anyone who knows how international arbitration works know that these judges would get paid way more as international arbitrators than to serve on the Hong Kong bench. And I also didn't like the fact that some Hong Kong activists actually started stalking Justice Keane. So I just want to put it on the record that, you know, if Justice Keane's seeing this, that not everyone thinks that stalking you is a good idea. Okay, I certainly think it's an awful idea, and I feel bad about this. So then I know that actually, as things stand, there is now bipartisan support in Australia asking the Australian judges to rethink their position on the Court of Final Appeal. And I've got 8 minutes to go. So now, why would I say they shouldn't say? Well, I guess the cheapest shot I'm going to take today is the one about optics. Okay, so we've got an Australian called Gordon who got convicted of national security law offences, who's still currently sitting in jail in Hong Kong. I've got a bounty over my head. Another Australian resident, Ted Hui, who's recently got refugee status here, has got a bounty over his head. So basically, you've got a situation where you've got a government that is committing transnational repression against us, and we've got our judges sitting there. And what's even more jarring was that shortly after Gordon got convicted, a number of English judges quit in protest, but Australian judges stayed. Now, I get that optics alone isn't going to be the reason why they should quit. That's just one factor. The second point is there is this whole debate about whether by being on the Hong Kong Court of Final Appeal, foreign judges, including Australian ones, are legitimising the crackdown and the deteriorating legal and judicial system there. Justice French, when he resigned from the HKCFA, made it clear that he rejects this notion. Okay, and look, I have no reason to doubt that the judges that are currently serving, the foreign judges, are not intending to be there to endorse the crackdown, okay? But it's one thing to intend, but it's another thing to see how it gets used. And you see that actually the Hong Kong government is not shy. You know, I'll let you read it for yourself. They're not shy about using the presence of these judges to promote themselves, okay? So I think that's actually very important when you think about what we mean by legitimization. It's not just what the judges subjectively think, it's also about how it gets used against them. So now comes what I call Justice Keane's red line. I'll talk quite a lot about Justice Keane, and I just want to make it very clear that the only reason why I'm doing so is because he did this bumper interview with the Australian Financial Review back in 2024, and you know, to his great credit, he's the only judge staying around who's given a full-throated defence of his time in Hong Kong, and I think he should be respected for that. even if I disagree with him. Actually, there's one other judge that Lord Newberg also gave some extensive defense, but he's a POM, so I'm not going to talk about him. So Justice Keane basically said, look, if we've got instances where the Hong Kong government looks like it's not respecting court judgments, then maybe that's a red line for him. Well, unfortunately, that's already happened twice, at least. Once before, sorry, next slide. Okay, once before he even got on that bench, there was a case where after the Hong Kong courts allowed a dissident to have a London Silk represent him in a national security case, basically the Hong Kong government sought an interpretation from Beijing to override it all, and the Beijing government issued a statement blasting the judges for applying so-called international standards. Interestingly, apparently the AFR journalist raised this point with Justice Keane, and she was, she got asked whether she understood what that was all about. Ironically, that journalist actually spent 5 years in Hong Kong before returning to Australia. So that's one case, and then there's another case that Justice Keane actually got involved with himself. Okay. Great. He was part of a 3-2 majority upholding same-sex civil union rights in Hong Kong. Fantastic. 2-year grace period for Hong Kong to implement it. Hong Kong chose not to implement it in full, but even the limited package got voted down by its patriots-only legislature, the no opposition allowed legislature. And the funny thing is that that same-sex bill was the only bill out of 130 that wasn't rubber-stamped by this patriots-only legislature, right? And so actually Justice Keane's own judgment got disrespected. Now here's the punchline. Next one. He's gone for a 3-year extension since then. So next point. So as a judicial independence, look, in Australia, trained in the technicalities of Chapter 3, we think very technically about judicial independence. But actually, atmospherics matter. And if we can go to the next slide. Yep, I've got 2 minutes. So, but the thing is, atmospherics matter. And look, I'll leave it to you to look at some of these points as I glide through them. But the reality is that if you've got things like, excuse me, next slide. If you've got things like the current Hong Kong Chief Justice saying one thing to an English-speaking audience and then praising the national security law and declining to defend the separation of powers when speaking to a Chinese language audience, when, errant judges who support Beijing get promoted and all of that, that creates an atmosphere where, understandably, judges who rightly think they're, deciding cases independently, would just be conditioned to rule in the quote-unquote right way. And in fact, we've had Lord Sumption, an eminent constitutional law professor, Johannes Chan, criticizing the Hong Kong judges for kowtowing to Beijing on national security and political cases. Next slide quickly. I'll be very quick. Look, I'm not going to go through these slides in any great detail. All I'll say is there's been Australia. Look, judicial independence is cold comfort, all right? Because when the laws are bad, what can the judges do? When the laws are enforced badly, what can the judges do, right? And also, a lot of the cases never get appealed, despite what Justice Keane might think. Next one. Look, I understand the foreign judges feeling sorry for the Hong Kong judges, but feeling sorry and being there isn't actually making things any better. We've had now nearly 6 years of the national security law. and it hasn't got any better despite these judges staying. So finally and very quickly, another argument is that, by staying there, seated at the table, they can help. Well, not really. I mean, things just continued as they are. And whenever the Australian judges try to do something that helps, it gets undermined immediately anyway. Next slide, and you can look at the words very quickly. There are a lot of them. And then yet another one. Next slide. Sorry, next slide again. Yep, and next slide again. Right, and now it's over to, I think the final point I would make is this. To the extent that there are non-political cases where Australian judges are still doing interesting things, well, why do we need them there to make a difference on cases that the Hong Kong courts already have a lot of expertise in? As Justice French himself said, it's arguably anachronistic. And as a segue to what Lex is going to say as our most erudite speaker, Singapore on the commercial side already has one of the most well-respected common law courts on the commercial side. Why do they still need foreign judges there to make a difference anyway? So it's the same with Hong Kong. I'll leave that thought with you all. Thank you.
Thank you so much, Kevin. You obviously paid a lot of attention to my firm directions. I'm now very happy to introduce Lex Lasry. Lex Lasry is a highly experienced Australian barrister and judge with a long career in criminal law. He was appointed as a Queen's Counsel in 1990 and later became a judge of the Supreme Court of Victoria in 2007, where he served in the criminal division and as a principal judge before retiring in 2018. He then continued in acting judicial roles until 2026, including with the Supreme Court of the Northern Territory, and now hosts the Law the podcast with Greg Barnes SC, which is dropping into our ears next Wednesday the 29th of July, so you can like and subscribe. Many of us will recall Lex's fierce advocacy alongside Julian McMahon for their client Van Nguyen, a young Australian who was executed in Singapore just over 20 years ago. Lex has been a long-time anti-death penalty advocate and sits on the advisory board of Capital Punishment Justice Project. We're thrilled to have him here today.
Thank you very much, Sarah, and I also acknowledge the traditional custodians of the land on which we meet. So, I'll start with a bit of context. This will all be familiar to most of you. The primary UN treaty aiming for the universal abolition of capital punishment is the second optional protocol to the International Covenant on Civil and Political Rights. It was officially adopted in 1989. It came into force in Australia in July 1990, and in 2010 the federal government in Australia passed legislation which prohibits any jurisdiction from reintroducing capital punishment, something that someone should tell Pauline Hanson about because she's in favour of reintroduction. So the abolition of the death penalty has had bipartisan political support. If I were still a judge, I would refuse to be a member of any court that imposed the death penalty. Realistically, the only court outside Australia to which that might apply, of course, is Singapore. So I'm not getting many invitations. Singapore has, in my view, a significantly different social values, and of course has a significantly different attitude to the death penalty and to civil liberties. But Singapore is committed to a mandatory death penalty for particular offences. It is one of only 5 countries in the world that executes people for drug offending, the others being China, Iran, Kuwait, Saudi Arabia, and did I say China, Iran, Kuwait and Saudi Arabia, yes. And it executes people while proceedings challenging those executions and the process of justice leading to those executions remain unresolved in the Singapore courts. And Singapore does its very best to silence or diminish the effect of groups which advocate for those who are condemned to hang in Singapore and advocate for the abolition of the death penalty. So there are two important issues: mandatory sentencing, which is a significant issue in itself, and death. The court, the Singapore Supreme Court, is obviously an instrument of the executive government in imposing mandatory capital sentences. Since World War II, it's estimated, maybe more than an estimate, but it's something of the order of 500 to 600 people who have been executed in Singapore. Last year, it was 17. This year, so far, it's 14. All have been sentenced to that penalty by the Supreme Court of Singapore. Now, that court hears civil and criminal cases. It consists of a Court of Appeal and a High Court, which has a general division, an appellate division, and it has, for the purposes of this discussion, the Singapore International Commercial Court. On that commercial court, there are a number of international judges. As Sarah said at the outset, 7 of those are Australian. They are the Honourable James Allsop, AC, the Honourable Anthony Pazanko, KC, the Honourable Robert French, AC, the Honourable Roger Giles, KC, the Honourable Douglas Jones, AO, the Honourable Anthony Ma, KC, and the Honourable Patricia Bergen. They all sit in the commercial division of the Singapore Supreme Court. Now, that Singapore Supreme Court shares a Chief Justice, it shares the institutional identity with the rest of the court, it shares the public reputation, and it shares the constitutional foundation, as well as the government authority, which, among other things, mandates the death penalty for particular offending. The presence on the court of those 7 Australian judges suggests, among other things, that there is some kind of seamless link between the Australian court system and the Singapore court system. That shouldn't happen. There isn't. There is no seamless link. There can never be a seamless link between 2 court systems, one of which executes people. You don't need me to tell you that death by hanging is barbaric, and indeed barbaric enough to contaminate the entire institution, despite what some would say has developed an international acceptance. I ask you to imagine the position of these 7 judges if the mandatory penalty in Singapore for drug offending over 15 grams of heroin were that the individual be publicly hanged and then quartered in the central square or in a central location in Singapore. People would be appalled, absolutely appalled that a punishment like that could be carried out. No Australian would want to be part of a court that did that. But hanging, as anyone who's had any understanding of it, as we know, is violent, it's degrading, it's physically grotesque, it's psychologically torturous both for the condemned person and their family. It's internationally condemned by abolitionist states and, in my view, and that of many, incompatible with modern human rights norms. A judicial system that performs barbaric executions is, I say, morally compromised in its entirety. If the institution kills people in a cruel manner, then, in my view, every judge who joins in as a member of that institution, at a minimum, is lending prestige to a system that engages in cruelty. This is not about participation, it's about contamination. Respectability and legitimacy is lent both to the court and to the Singapore government by the acceptance of appointments by these 7 Australian judges. You cannot lend legitimacy to one part of an institution without lending legitimacy to the whole, which in the legal context includes the death penalty. By joining the Supreme Court, these Australian judges inevitably strengthen its authority, something that Kevin was pointing to a little bit earlier, including the authority to use to impose a mandatory death penalty. Whether intentionally or otherwise, and I don't suggest this is done intentionally, but it's the reality of their participation, they legitimise the death penalty imposed by the court and, of course, mandated by the government. They should not be members of any aspect of the Singapore Supreme Court, not the commercial court, and in my opinion, they should resign. Thank you. I know. No, it's just a little test.
Thank you so much, Lex. I'm now going to call Rebecca back to give us some reflections. Now we've heard the very kind of country-specific words and reflections of Kevin and Lex.
Second guessing my decision to be the act that follows Lex Lasry a little. But thanks, Sarah, I knew there was nothing I could say that would be that powerful, and I wanted to hear what these guys had to say before I reflected on it and got beyond the big picture. And one thing that I was thinking about is the fact that doctors take an oath not to harm. And if a doctor who had taken that oath then joined a hospital where harm was something that they did, then, well, we'd expect them to walk away or not join it. The oath that judges do is a lot more vague, but it is the effective administration of justice. And what we've heard about are contexts where justice, and you can call that rule of law, you can call that fundamental rights, but justice is seriously undermined. And it's being undermined through law. These governments are using the law, and that means using courts to undermine the justice system, be it civil and political rights or the right to life and proportionate punishment. Now, no one stands up for courts in the justice system, really, except for courts and judges. And this is the space where judges do have a very heavy weight upon them to stand up in the interests of justice. And that runs against a lot of the culture of quiet, dignified going along in legalism. But making that decision to stand up and say something, whether it's to walk away or say something, and we've had a whole variety of different responses from judges in these two countries, doesn't have to be based on political views. They can look at the fundamentals of the role, and it was interesting for me reflecting on that oath that they take. And I think if it's a situation where a judge really looks at what they've committed to doing and thinks, I can't fulfill that, then they shouldn't be there. And there's a lot of aspects to that. There's the independence and integrity and justice aspects. There's recognising that they're there quite explicitly to lend the institution legitimacy. And then something that Kevin and I have been talking about that didn't come up there is you'll find it in the Hong Kong oath that the judges actually swear allegiance to Hong Kong and the People's Republic of China. And that's not cookie cutter language, in case it looked like it. There's an ordinance that's been issued that runs for 2 pages dictating exactly what allegiance to the basic law and to Hong Kong and the People's Republic of China entails. And it entails agreeing with a whole lot of political standpoints. For instance, any advocacy or action or like support for, say, a referendum in favour of or a referendum on democracy would be breaching that allegiance. So if a judge really, really thinks about it, I would be surprised if they could uphold everything in that oath. But at least they need to think about it long and hard. Right. Thanks.
Thank you. We'll now open up for some questions. Yes.
Thank you, and thanks to all the panellists for your wisdom and sharing it with us today. I just wanted to ask around, I think it was Caitlin on the earlier panel who was talking about how in Australia, human rights often need kind of another vessel of sort of like public law issues to be able to change any sort of rules around the human rights or to uphold the human rights better. I'm sure I've botched that paraphrasing wherever you are, but I think it's interesting when we talk about that oath, Rebecca, and like, how does that play into judges being panels even in Australia if in their opinion they're not upholding human rights or justice in that way? And when is it only the death penalty for you when it becomes like that's too much of a miscarriage of justice to be that a judge can be on that panel, or are there other levels of injustice that you would say they have a responsibility to us and their oath to resign? That would be my question.
So, yep, I can answer the Australian one pretty quickly because there's a more interesting point there. And that's that our judges declare that to be unconstitutional. So when we've had, very recently in the last few years, courts have been asked to uphold the indefinite detention of asylum seekers, of non-citizens, they've said, well, no, that runs against separation of powers and we're not doing it. So we have that protection, and it's the courts themselves that have, as everyone knows because you've all memorised your Chapter 3 doctrine, the courts themselves have developed that out of our dried up nothing there constitution and strike stuff down all the time to uphold their own independence and the effective administration of justice. So we have something here. If we got to the point that there were gross kind of injustices that the courts are being expected to do, and there wasn't an avenue for them to say, no, that's unconstitutional, you can't say that, then yeah, I think that would be time for the courts to stand up and for judges to maybe walk away.
I think there are degrees. Excuse me. If by some miracle the Victorian government found a way to reintroduce the death penalty in Victoria and I was still a judge of the Supreme Court, I would have immediately resigned. That's completely hypothetical because it was never going to happen. But there are other things that cause aggravation, at least to me, which wouldn't require resignation. But I always struggle with mandatory sentencing because to me, mandatory sentencing is really the executive saying to the courts, we don't trust the sentencing discretion, therefore we're going to fix a minimum for this regardless of the circumstances of the case. In the Northern Territory where I recently sat, there's a mandatory maximum of life imprisonment for murder, and if under the current law, if the deceased is a partner, domestic partner, there's a mandatory minimum of 25 years. That's the best that the accused can do upon conviction. I find that completely repugnant. But somehow or other, I've been able to rationalise myself to remain part of the system, not anymore, but I had, even though there would be occasions on which I would have to impose a mandatory sentence. So I guess that simply demonstrates that there are degrees, some things you can learn to live with, and just hope that somewhere in the legislation there's an exceptional circumstances clause that enables you to avoid it, but a death penalty is completely beyond the pale and should be for these 7 Australian judges. It's not a complicated process. They should look at it and say, I am part of a system, even though I'm not part of the criminal division, I'm part of a system that kills people. I can't be part of it.
Just very quickly, I thought what Rebecca said about Australian judges in Australia being able to, strike down laws for unconstitutionality. Just contrast that with the situation of foreign judges in the Hong Kong Court of Final Appeal. National security cases can only be heard by designated national security judges, and no way on God's earth would any foreign judge be on it, so they can't help with those. In any event, the national security law is said to be unreviewable from a constitutional perspective by Hong Kong courts, and that if there's any conflict between the national security law and Hong Kong's mini constitution, the national security law prevails in any event. The third point I would make is that there is, I want to return to the question of atmospherics and culture, because one of the things that Lord Sumption mentioned, unlike Justice Keane, who said he asked the judges in Hong Kong whether they were conducting show trials, and they assured him that no, we're not conducting show trials. a senior Hong Kong judge was willing to be frank to Lord Sumption and said, hey, atmospherics do matter. You know, I know that even if I rule in a particular way, the National People's Congress can reinterpret everything and overturn what I do anyway. So, and I can't be fighting a guerrilla war against Beijing all the time. So I've just got to go with the flow. It is at that point that you've got to start wondering, why are the judges staying?
Thanks very much for the excellent discussion. I actually also, Kevin, used to be working as a human rights lawyer in Hong Kong, so it'll be great to have a chat. I totally agree with you about your analysis of the situation of Australian judges on courts, the Court of Whanau in Hong Kong. It's not just the effect of the national security law in practice, but the chilling effect that's happened in Hong Kong, and the fact that there are so many now people that were working on human rights that are either in prison in Hong Kong or have had to flee overseas. My question is more a sort of practical one, which is in the context of Australian judges. Obviously, it's a sensitive issue where they are independently, and usually after they've retired from being on courts in Australia, where they decide themselves whether to take up positions. But in the context of codes and such as the Bangalore Principles, what else can be done either at an international level or in Australia in terms of our national codes regarding judges on issues of where judges may be on benches overseas in jurisdictions which may not be upholding human rights? Thanks.
Sure. On wider principles, I will defer to the expertise of Rebecca. But first of all, I was actually not a human rights lawyer in Hong Kong. I was a commercial litigator who, unusually enough, and actually from all the words that I had on my slides, you can see that I've got commercial litigationitis. But on a serious note, I think one thing that we've once judges retire, you know, they are private citizens, and in a free society, as a general rule, we shouldn't be telling them what they should or shouldn't be doing. You know, they have roles that they can or they can take up if they want. That said, in the case of at least superior court judges and above serving on foreign courts, as I've mentioned earlier, for all their individual legal acumen, they're being asked to go to these foreign courts because they're Australians. And so at some point we've got to ask, should there be codes or even mechanisms in place where Australia's national interests or Australian legal systems reputational interests need to be taken into account before these judges take up various foreign judgeships?
So I'm a nerd, and I am like, ooh, judicial accountability. And the common law system has had issues with judicial accountability and complaints and regulation forever. You know, these are gentlemen's agreements. The answer, one answer is that a lot of that accountability is left to the legal profession itself, and pressure from the legal profession and that profession's opinion of that person carries a fair bit of weight in real world accountability in places like Australia and the UK and Ireland, where we don't have, as they do on the continent or in Latin America, much more regulated formal systems of complaints management and accountability. But there is an accountability and independence lack, not gap, but lack in when you have a judge on a foreign court. The way it's usually talked about, though, is one of those key protections for independence, security of tenure, isn't there necessarily for a judge on a foreign court. They're appointed for a limited amount of time. They may or may not be offered a renewal of that term. Stuff we would never kind of think about here. So most of the literature in this space around judges on foreign courts concerns that ability that their independence may be compromised from the local government, where the court is, which might fire them or not hire them. It's not on this side of it, which is whether the judge should stand up for themselves and walk away. That pressure would come from their home jurisdiction, I suppose, and here that's a very cultural pressure. It's a gap, yeah.
I agree with Kevin.
And also just going back to your point, Kevin, that you made so quickly because you were under my duress, around the bipartisan, there's been bipartisan support for judges in Hong Kong to step down within.
Well, I would frame it a little bit more circumspectly than that. I think the bipartisan wording is the judges should reconsider their positions in light of the Australian government and the Australian opposition's concerns. I mean, so they didn't explicitly tell the judges to go, but I guess the point is, thinking back to the culture point, two things on that. One is, well, that's why I'm here. I'm trying to talk to people in the legal fraternity here and explain what's going on. And also that's why, I'm so death by a thousand cuts about some of those points, because lawyers would like to get into the details of these things. The second thing, of course, is it's also worth them looking at what their counterparts in other jurisdictions have done. In the case of the UK and Canada, virtually nearly all their judges are gone. There are only 2 UK judges left in Hong Kong, one of whom is 93 years old. So, not meaning to be ageist, but I think you get the drift. So why did 12 people go and 3 people join and a few others stay? So that's something, from a peer-to-peer pressure perspective, it's also worth them reflecting on, I think.
Thanks very much for your very powerful presentations. Penny Matthew, ACT Human Rights Commissioner. I just wanted to ask whether you're drawing on other kind of precedents or analogies, and the ones that sprang to mind for me were, first of all, humanitarian actors, like the UN, for example. When is it better to just pull out of a country rather than be involved in trying to aid the citizens? And then on the judiciary, a couple sprang to mind. Obviously the judges' trials after Nazi Germany. And then I started to think about, of course, the United States and Harry Blackman saying, "No longer will I tinker with the machinery of death," when he finally decides to dissent in death penalty cases. So is it helpful to draw on some of these other either analogies or precedents in determining where to draw the line?
I'm not sure of the answer to that as far as my particular topic is concerned. I don't get the impression that any aspect of the activities of the 7 Australian judges in Singapore is aimed at in some way affecting the future of the death penalty in that country. If they were in the room now, they would say my criticism of them is very unfair because they have nothing to do with it. They don't sit in the criminal division, they don't sentence people to death, so why should I leave? I'm part of an entirely autonomous commercial court that has nothing to do with the criminal law, which to me is really missing the main point, that they're part of an institution and indeed accepting appointment from a government that mandates the death penalty and has killed people, as I said before, over now a lengthy period of time. So I don't think the analogies really would apply in Singapore. I mean, as I say, I don't think any of the 7 are saying, well, you know, I'm working quietly behind the scenes and I'm lobbying the government. After all, it is Australian policy that the death penalty be abolished worldwide. None of them are doing that, as far as I know. They're just taking the money and sitting in arbitrations or mediations in the commercial court. So I don't think there's a similarity.
Interesting you should mention Nazi Germany. Look, I'm not intending in any way to suggest that the Australian judges in Hong Kong are comparable to the situation in Nazi Germany per se, but given that you mentioned Nazi Germany, I think, you know, actually the example that springs to mind is not from the law even. It's actually, for those of you who are into classical music, it's actually from the then Berlin Philharmonic Orchestra chief conductor Wilhelm Furtwängler, and he decided to stay in Germany after the Nazis came to power, despite his personal distaste for the Nazis, thinking that by doing so he can help save Jewish and other dissident musicians and artists. But the Nazis took advantage of him staying by appointing him, you know, without consulting him, as the Reichsdirektor of music over Germany. And despite Furtwängler's own good intent, after the war, his reputation suffered, you know, for the rest of his life as a result, even though he was allowed eventually to do some conducting afterwards. And so I just want to bring it back to the point that what individuals intend, thinking that they're being of service, thinking that maybe I can make things less bad. One, can you really make things less bad? I mean, Furtwängler did kind of save Hildemith a little bit, but not many others. And the second thing is, others can use your, if I may be blunt, can use your naivety against you for their purposes.
I think my question sort of adds a little bit onto that. I'm wondering if there's a sort of level of cognitive dissonance. I think Australian judges come through a system where there's parliamentary supremacy. It's not up to them to determine whether a law is good or bad, but just apply it as written for the parliament. And in a lot of cases, judicial activism is discouraged. Could that be a potential justification in the minds of some of these justices, being like, well, my job isn't to determine whether a government's law is bad or good, but whether, you know, just to apply the law that I'm asked to apply in the area I'm asked to apply it? Could that potentially be, not that I agree with that, I'm vehemently against that sort of belief, but in my mind, sitting there being like, is that a potential argument they could be telling themselves?
I'm happy to start, and yes, I think that this tradition of Dixonian strict and complete legalism is one of the reasons, just, you know, what do I know, but this is my thought, why there's still 3 Australian judges here and so many Australian judges there. Yes. I think that Australian judges, thanks to that tradition and the absence of a human rights, you know, National Human Rights Act culture, they're not interpreting in that vein. The kind of prickliness that you get to human rights language in court argument and jurisprudence can give the impression that applying the law as the law is written is justice. And I don't think you'd need to push. These are intelligent people. They know that that's not true, but there is that entrenched culture that just does need to shift and be questioned. And I'm hopeful under the Gagler Court we're seeing a lot of engagement with liberty and the kind of values and rights that inhere the common law tradition and those kinds of things, and that we can move into a more values-based space. But it's a long tradition we're wrestling with, and I think that they're definitely in it. Yeah.
Joel?
Hi. Sorry. As a Singaporean, I just had questions with respect to that. To be very clear, my position. Oh wait, is it live streamed? Just take it off because like. Is it recorded?
So maybe don't ask John. Yeah.
Talk to me outside afterwards. And I promise I won't record the conversation.
Yes, you have a question here.
Hi. I came from a country with severe violations of human rights in the Philippines. May I ask your views about Australians who commit heinous crime in other countries, like Thailand or Philippines or Singapore? Because you don't agree about death penalty. So what?
Well, if you're asking, there's been a recent case in Thailand, of course, where a man has been arrested, charged with the murder of a young girl, apparently almost at random, that he picked up at 3 o'clock in the morning, which reads so far like an appalling case. And as far as I'm concerned, if he's found guilty of that offence, then he should be subjected to a very significant penalty, which in my view is worthy of being imprisoned for life. But my opposition to the death penalty isn't to do with particular cases, no matter how savage. I am, and I don't know if you remember this, but I am of the view that Richard Burke, who was mentioned earlier, said to me probably 25 years ago, I just do not believe in governments killing people. And that's not what the justice system should be about. Punishment by all means, but government should not kill people.
Thank you. I think what we might do is draw to a close. I might ask each speaker if you've got any kind of final reflections that you want to share. No?
I think, actually going back to one of the earlier questions, the other aspects, leaving aside Dixonian legalism, I think the other aspect that draws Australians to stay, say, in Hong Kong at a time when the British are all leaving, is also the way we conceive of the role, what judicial independence is, and also what the role of judicial independence is in the wider scheme of the rule of law. So for those of you who've done a lot of constitutional law, you would know much better than me the formalism and the technicalities that go around Chapter 3 case law in Australia, and it potentially breeds a mode of thinking where, so long as there's no evidence of someone literally tapping you on the shoulder to say this is how you must rule, then that's independence. The second thing, of course, is that, again, because in the absence of entrenched human rights at a federal level in Australia, and the use of Chapter 3 as almost like a proxy human rights guarantee in this country, you've got this situation where judicial independence as a concept has taken on an outsized importance in how we think about what the rule of law is generally. And so when we hear Australian justices defending their staying on the Hong Kong courts, they basically rely on the good chaps defense, right? Which is, the good chaps on the Court of Final Appeal that I deal with, they look pretty independent to me, and because in Australia, there is this sense of, if the judiciary is independent, you've got the rule of law. And you kind of forget that actually, even judicial independence, judges are a little bit like a train driver, right? Like, you can only defend the rule of law for as long as the train tracks lead you the right way. And if the train tracks lead you off a cliff, you've got no choice but to go off a cliff with it, right?
My wash-up, I think, would be there's a role for the Australian government. Every time you hear an Australian government minister being interviewed about anything to do with the death penalty, they will always say, well, of course, Australia has always been opposed to the death penalty, and we do everything we can to spread that across the world and persuade other countries not to impose death penalties. Well, the Australian government ought to consider endeavouring to persuade retiring Australian judges not to accept appointment in Singapore as a death penalty country.
Thank you so much. I really want to thank our speakers. Rebecca, thank you so much for giving this context and framing it for us. And Lex, thank you so much. I can assure you Lex Sasser is one of the only judges who has been happy to speak on this topic, and it's really important that we have these conversations. And Kevin, coming from a deeply personal lived experience, but also incredible expertise on this issue. So thank you so much. I invite everyone now for afternoon tea and to come back at 3 o'clock for our treaty panel.